Good afternoon, everybody, and welcome to the TUC's webinar programme for 2024. Happy New Year, because this is our first webinar of the year. I'm sure we've got lots of new people who've joined us for the first time today. If so, welcome. It's great for you to join us, and welcome back to anyone who is has been with us before. It's great to see you again. So, for those who are new, you can follow along today with our live captions. There's the green button underneath the videos. So if you click that, you'll be able to open live captions in a new screen. To do that if you would like to. We are recording today, as always, and we will send out a link to the recording along with any resources following the webinar, and we're going to send those to everybody who's registered. You'll get that email later today or tomorrow. You can post your questions for us in the panel on the right hand side. There's a speech bubble with a question mark in it, so please post your questions there, and we'll answer as many as we can after we've heard from Tim. So I'm delighted to be joined today by my colleague Tim Sharp. He works in our employment rights team here at the TUC, and today we're going to be talking about a very important new law that is going to affect many trade unionists because of the changes it's bringing in. So we're going to find out a bit more about that today, because I'm going to ask Tim some questions so that he can explain to us what we can expect going forward. So first question, Tim, what is an MSL?
So this is a minimum service level. This all has its roots in the summer of 2022, when Rishi Sunak was defeated by the dazzling political brilliance of Liz Truss, and both sides competed to sign more anti-union, anti-worker than the other, and they both came up with this idea of a minimum service level, which is a law that says that a certain level of service should operate during times of industrial action. And what we've ended up here is something with two stages. The first stage being a Secretary of State will propose regulations setting out in this particular service. It might be ambulance, it might be schools. This level of service will have to operate during strike action, and they can cover 6 sectors: transport, health, fire and rescue, transport, decommissioning of nuclear installations and management of radioactive waste, border security, and education. And I think I might have said one of those twice because my fingers went up to 7. So that there's one stage. The first stage is what the Secretary of State proposes, a regulation. But secondly, and crucially, the government itself doesn't enforce it. So it'll be up to employers, if they wish to issue work notices to the unions involved in the strike, naming who should work and what duties they should carry out to fulfill those MSL regulations.
That's really helpful, Tim. Thank you. So you've already mentioned the sectors that it will apply to, education, health, etc. Does it affect everybody in those sectors, or is it just particular jobs?
So we've calculated that it could affect up to 5 million people if all those services and all of those sectors had minimum service levels imposed upon them. But as I mentioned, it requires the government to pass regulations for those particular services. And so far, this has happened for 3 services: for passenger rail, for border security, and for ambulances. And the minimum service levels are quite different. There's no great, this may surprise nobody, there's no great government vision for what industrial relations should look like. It's very different in each service. So in rail, broadly speaking, the minimum service is meant to be 40% of timetabled services, plus, as far as signallers and so on are concerned, key priority routes kept open. In border security, the service is meant to look exactly the same as it does on a non-strike day. Make of that the government's commitment to the right to strike. And then in ambulance, it's to do with the number of calls that the type of priorities of calls that are picked up. What we do know is that what this means is that in many services, some people will have their right to strike completely denied to them. I mean, in border security, for example, even the government's calculations is that 3/4 of staff will have to come in in order to operate a minimum service. It probably might have the same things in parts of rail as well. So that's the picture so far. But if the government wants to extend that to other services, they've talked about wanting to do something in schools and colleges and universities. They've talked about hospital services, consulted on that as well, and they've also consulted on fire and rescue. Those will be separate regulations passed by Parliament with a completely different set of what does the minimum service look like for those particular areas.
So we don't know all the detail yet by the sound of it.
Exactly, yeah.
Okay, so that's interesting. So if I'm a union rep in one of those sectors, what's this going to mean for me?
I mean, I think some of this will be down to how your union operates and how your structures work and the sectors you're in. I mean, so big picture unions will have to think about strategy. You know, do you engage? You know, will unions maybe look to alternative tactics to avoid engaging with law at all? You know, things like action short of a strike. Maybe unions will focus some of their campaign on pressuring the employer not to issue a work notice at all. So there'll be that consideration to go on. Part of the process will also, if the employer is intent on issuing a work notice, part of that will involve a consultation with the union. So one of the few obligations that the law places on employers is to consult with unions before issuing a work notice. And this is going to happen between when the union issues the notice to strike, which is 14 days before action, and then the employer has to issue the work notice 7 days before action. So in that period, that consultation has to happen with the trade union. That might be a role, depending on how the union works. That might be roles for sort of reps there. And the law says as well that the employer must have regard to any views expressed by the union. So there's a job there to keep an eye on quite how seriously the employer is undertaking their consultation duties. And there'll be a role as well about monitoring. If an work notice is imposed, then the law is clear that employers must not take into consideration a worker's trade union membership or related activities. So have you taken part in union activities, for example? That shouldn't be taken into account when deciding who's on a work notice. There'll be a job there of kind of checking out, well, it's rather suspicious that suddenly everyone who's active in the union branch is now named on a work notice. There'll be a sort of, or do the same names appearing again and again as well. So that's something to look at. And, you know, unions might want to think about things like subject access requests. You know, what has gone on in background to ensure those people are named. And the other thing is that the law says that the employer shouldn't name too many workers. There are enough workers to fulfil the minimum service and a bit of leeway in case of sickness or other predicted absence. But, you know, they shouldn't be delivering more than a minimum service by bringing in loads more people as well. So there's a kind of monitoring job there as well.
Thanks, Tim. So that's a lot of new things for reps to be aware of. But I think it's important that we emphasise to reps that it's always going to be a little bit different depending on your union and depending on your sector. So always consult with your union, with your full-time officer or whoever your contact is, maybe in your regional office, depending on the size of your union, to find out what they advise and what their strategy is around this. So next question is from relations with employers, really. Could my employer discipline me, either like as a rep or if I'm a regular worker?
Now, what the law doesn't do is it doesn't give the employer or the government the power to force someone to go to work. That would go beyond even wartime powers. But what it does do is it removes from someone named on a work notice the automatic protection from unfair dismissal that you usually enjoy if you're on strike. So that means that someone who's named on a work notice but doesn't attend could be disciplined or even dismissed if they take strike action. So the consequences are potentially incredibly serious.
Okay, so that's worrying. That's worrying to hear that an employer could discipline anyone who's named in that situation. And I think our advice for anyone in this situation would be to speak to their union, their full-time officer, for individual advice if such a thing were to arise. So also with regard to employers, are they bound to do this? Do they have to follow this law?
Now, this legislation involving minimum service levels is very clear. Issuing a work notice is at the discretion of an employer, and that again was emphasised by ministers in Parliament. However, employers might decide that they have other duties, maybe statutory duties or contractual duties that mean they feel they have to issue a work notice. So you might think about a hospital where the management might decide they'd be more liable to someone to seek damages if somebody some sense of understaffing, or you might be government pressure, for example, on a train operating company to do with their contracts. So this law is very clear, totally at the discretion, but there are probably other things that employers will feel they have to take into account. But what's quite noticeable is we have, the TUC in its campaigning work, we have worked really closely with, we've talked to the Scottish Welsh Government, have put out statements about they're going to do everything they can to avoid the issuing of work notices in the areas. The same for a number of city leaders and regional mayors as well. So there is a groundswell of opinion amongst, basically good employers are going to try and avoid to do this. It's going to be bad employers, those spoiling for a fight, are probably the ones that are going to issue work notices.
Okay, so that's interesting. We've already got some employers saying that they're not going to issue them, which the law allows them to do. The duty's on them. Will work notices that are issued by an employer be public, or are they a private document with employees?
No, there'll be a private document. Unions have to be quite careful about how they manage the data protection element of this. Trade union data has particular protections, given the long-standing history of union members and activists being targeted and even blacklisted. So what will happen is the work notice will be sent to a union, and this will happen. The work notice has to be sent 7 days before the action starts and can be amended 4 days before the action starts, and that union will then be required to sort of basically cross-reference with the membership database and send communications to those members named on the work notice, say you've been named, these are the consequences, and the government has set out in quite some detail in the related code of practice what should be in this communication from unions to their members. And you can see the potential challenge when it's a national dispute with hundreds of thousands of members and trying to unravel 320 Jane Smiths and exactly what jobs they have and are they union members or not. So there's going to be a major logistical challenge for trade unions, but that work notice will not be issued to union members themselves or to the workforce themselves. So employers may decide to contact those on the work notice independently by themselves and say, you're named, you need to be coming in on this date.
So just to clarify, who would receive the work notice?
So the work notice will be issued to the trade union.
That's great. So you talked a lot there about information, names, contact details, basically data. Now we know through lots of our work in TUC education that keeping accurate records of members is really important to be an effective rep. We know this isn't always easy because you can't always get the information, but perhaps this is a good opportunity to make sure that records are up to date so that you can contact people, and crucially that members know who you are so that they can contact the rep. They know who you are, they know how to get in touch with you if this situation arises, if they're issued with a work notice. Okay, so we talked a lot about the procedural aspects of all this so far. So what's the situation around if a strike occurs when there's a minimum service level, a work notice in operation? Could we still have a picket line at a workplace?
Yes. Now, the code of practice the government's brought in has brought in additional duties, and particularly for picket supervisors. And that code says that the picket supervisors should use reasonable endeavours to ensure that picketers avoid, so far as practical, trying to persuade members identified on a work notice not to cross a picket line. Now, that's obviously going to be really complicated because we know from what we just said a minute ago that work notice is not going to be a document that's going to be on the picket line. So being able to identify who is named on a work notice and who isn't is going to be extremely difficult. It's going to sort of people walking past the picket will just say I'm named on a work notice and trot off, and the code of practice puts that restriction on it. And just because code of practice could be the importance of it is it could be taken into account in any sort of subsequent legal proceedings when determining whether the union has done its duty in taking reasonable steps to comply with the law. So this is where this law has sort of grown tentacles and broadened out even from what's on the face of the actual legislation into now governing picket lines as well. So yes, picketing is still allowed, but they just have to be careful. But at the end of the day, with the exception of those who have told the picket they are named in a work notice, the picket may still seek to persuade other workers to strike.
Thanks for that, Tim. I'm going to have a look in a minute at the questions that have been submitted from our viewers. Before we do that, could you just briefly again just walk us through the process of how this would be put into practice? So, for example, a workplace passes the ballot to have a strike. What would happen next?
So the union then issues a notice of strike to the employer, and the employer will probably contact the union and say, well, we intend to issue a work notice. We believe we fall within the minimum service regulations. They will then consult. They'll go through a consultation process with the union around sort of how many people might be required and so on. Then 7 days before the action starts, the union will be issued with a work notice that will name those individuals who have to come into work and the duties they will undertake. That will include a mixture of union members' names and might include non-union members as well. So it's going to be a really complicated job. And the employer can then amend that list up to 4 days before the action starts. And particularly when you consider that includes weekends, bank holidays, getting those notices out, the subsequent notices that unions have to then send to their own members, it's going to be very hard to get them out in time if they're even relying on email or first class post. That's going to be a major undertaking for the union. And I just think just one other thing I was going to pick up on, Anna, that we haven't really touched on, but actually the consequences for the trade union of falling foul of this are really serious. So we mentioned what could happen to an individual. They could lose some of their protections against unfair dismissal, but actually a union could face damages as well. If it's deemed not to have taken what's so-called reasonable steps to get members to comply. And people want to remember that it was about quite recently the government raised the cap on damages to £1 million relating to what we deemed unlawful industrial action. Now, it's a fairly untested bit of the law, so we don't know exactly how it would be applied, but you can see really quite quickly how a union could have some real severe financial damage from following the wrong side of this legislation. And I think that's not this is what this is designed to do. This law isn't as much as there may be some pretense that it's somehow helping working people. This is designed to scare people off taking strike action and another lever to attract trade unions as well.
Thanks for that clarification, Tim. And yeah, we probably should have covered that a little bit earlier. The penalties for the union are significant, and that's that's obviously what the government sees as the purpose of this act. So I'll actually, one of the first questions I'll put to you, Tim, is do we expect this law to be now? This is it forever. There's no way of changing this. We've talked a little bit about the TUC's campaign. And we've posted a link to you all about the work we're doing. Please do take a look at that. But do we expect this to be it now?
So we know the law is now active for those three areas for passenger rail, border security and ambulance. And we may yet see regulations passed in some other areas as well. I mean, what was, in our campaign against this law, what was notable, particularly in the House of Lords, was a cross-party, a couple of Tories, but basically all the opposition parties or united in thinking this is ridiculous. This is unacceptable legislation. It puts us way beyond, way on the extremes of sort of international practices in terms of workers' rights. And the Labour Party has said repeatedly that it will repeal the minimum service legislation if it gets into office. Now, obviously, it's incumbent on our movement to keep that pressure on and make sure they do so. And the events like the march the TUC is holding in Cheltenham this month are our chance to send that signal and saying, this is completely beyond the pale. It's not acceptable. And keep the pressure on for it to be repealed. But there's, if there's a change of government, there's a very, this legislation should be repealed.
That's great to hear. And you mentioned a key date there, Tim, on January the 27th, I think it's January 27th, there is an event in Cheltenham where we are having a march and rally to protest against this law. We'll post a link for you in the chat. Please do have a read and come if you can. It will be great to see you there. Okay. One of the questions we've had from the audience, Tim, is saying, is there a way to test or challenge what that minimum service is? And if so, how? Like, who decides the minimum service?
So the actual minimum service is set out basically in the law. It's in regulations in Parliament. So for rail, for example, it'll say 40% of a timetable service. Now, this is, the complications will come is, what do you mean by a timetable service? There can be different timetables even within one train operating company. Does it mean 40% of passenger journey? There's all sorts. So there's going to be a lot of wrangling around what exactly does this mean. I think this is going to be very, very good news for lawyers. I think both unions and employers are going to spend a lot of time in court on this, and you may suggest this isn't the best use of public funds or union funds, but that's the reality of it. This is new, untested law. No one has yet issued a work notice. It's only been the regulation only been in these sectors only been in place for a month. But we'll get a better idea if and when things come to the courts. But no, on the face of it, stuff's in legislation. What exactly does that mean? Probably going to be the subject of sort of arguments between unions and employers, and ultimately perhaps settled in the courts.
Do we know when the first work notice might be issued?
We don't yet. I mean, there is potential industrial action even as soon as the end of this month. Will there be work notices? We don't know yet. I mean, you would hope that employers would see sense and understand that work notice is not issuing a work notice is not a way to resolving dispute. Is the way that a dispute will a way to inflame a dispute and make it harder to resolve. And you'd hope that sensible employers would turn their attentions to sitting down at a table, negotiating, working with unions rather than sort of working with their lawyers to explore the potential on this new form of law. So no work notice yet. Who knows when the first one could come.
Well, let's hope that they do speak with trade unions rather than lawyers. But as you said, this might be a very lucrative period for employment lawyers coming up for who work for the employers. Right. Is there a duty in the new law for employers to consult with unions or not? Read the work notices specifically.
Yeah, so there is a duty to consult. Now, what there isn't is a duty to agree. So the law says that the employer must have regard to the union's views on the work notice. So one of the things you might do as a rep might be, if you're involved in that, is kind of have a sense of, is the employer blatantly not having any regard to it, and is there potential for challenging work notices on that basis? I think it'd be very hard, but that's one of the things that you would look at. But I mean, the period for consultation is likely to be very short. It could be just be a week. So I wouldn't, I don't think the legislation is designed to facilitate meaningful consultation with unions, but it is there. It is there as part of what the employer has to do. And I think perhaps if you're in a workplace and there is a dispute, you might point out to the employer that they have, do they really want to undertake, they've got onerous duties on themselves, and maybe they want to think of other routes rather than issuing a work notice that might be less legally risky for them as well as for unions.
Thanks, Tim. That's really helpful. So some of the sectors that we've been talking about will maybe have contracted rest days, for example, as part of their normal working life. Would, say, for example, someone is named in a work notice, but it falls outside of those normal contractual terms, patterns, etc. Do we know what might happen then? Does the individual have any recourse?
It should, as it stands, the work notice should require you can require you to do your normal duties and shouldn't require you to do duties beyond that. So that should respect things like working patterns. Now, the question then becomes, how do you resolve that situation? And what there isn't baked into this is any sort of, you might at that point a worker might contact their employer and go, I shouldn't be on this because I don't work that day. They might contact their union, but there's no formal appeals process or anything like that baked into it. So resolving those situations is potentially tricky. So I think if you find yourself in that position, you speak to your union first of all.
Thanks, Tim. Yeah. As many of these sectors will, like we said, going to have different strategies, and the way this will work will be slightly different. Always, if you're unsure, contact your full-time officer for advice. Okay, you mentioned a little while ago, Tim, about not quite strike action, but action short of a strike. Would this new law have an effect on this? Like, for example, the overtime ban that we sometimes have seen in rail. What's the deal there?
So this legislation specifically covers strike action and shouldn't cover other forms of industrial action. Now, I think you get into the legal nitty-gritty and some of the boundaries between those are a little bit blurred, but this is very much specifically to do with strike action and shouldn't cover action short of a strike. So we may see, and I imagine different unions will take different approaches, but you may see unions considering what action they can take short of a strike, particularly in those areas that rely heavily on overtime, for example, in order to operate.
And a kind of question related to that, we know that there are some sectors in the workforce in the UK that have a lot of vacancies. So could there be a situation where a work notice is issued and there aren't actually enough people employed to meet that level? Do we think that could happen perhaps in health or?
Yeah, I mean, I think one of the ironies of this is, could we end up on strike days? Could the minimum service required on strike days mean that actually the service on strike days is better than the service on non-strike days? And you could see that, you could see that potentially happening in areas, if they do impose it on hospitals. Obviously they can only call in the number of people they have, but I think unions will be looking very closely. If you've got your entire workforce being called in to cover a minimum service, then have you actually effectively got rid of people's right to strike? And we're continuing to work closely with unions to explore what are the opportunities for legal challenge, where are those clearly, where are these regulations clearly overstepping the right to strike and just mean that people cannot exercise that ability to refuse to come to work to defend their terms and conditions.
You mentioned there, Tim, that we're exploring options with our unions about legal recourse here. Is there an approximate time frame on that? Do we know when we might be able to look at this a bit more, or is it still too early to say?
There's a window of opportunity where potentially if unions have taken the advice that that the regulations could basically are illegal. There's a window of 3 months to challenge from when they were tabled. So I think unions will be making decisions just in the coming weeks about what to do and whether to challenge. But we've been concerned and we unions will be thinking about things like how not only sort of the letter of the law, but what is the likelihood of British courts looking favourably on a union challenge, and courts haven't always been particularly union friendly. But I think we may see action in the very near future. But it'll take the court process also is delayed. So while a legal strategy is really important, if you take a case now, it could be October before it's even heard, at which point you might have a general election. So, all along through this, we've us and affiliates have taken sort of multiple strategies. We've worked to try and defeat these laws in Parliament. We've kept an eye on the legal strategy. We've appealed to international bodies. We're taking to the streets in Cheltenham, and people will fight these in their workplaces as well. So there's not like one solution to this, but I think a legal element will. I think a lot of people are looking at that right now.
Yeah, that's great to hear that we're not just we're exploring all options really to challenge this new law and make sure that it's not successful, and that make it as hard as possible really. Okay, my next question might be it might be quite a tricky one because it involves data, and we know this is quite complicated. If we've got a multi-union workplace, for example, the person asking here has said there's 3 in their workplaces. Could there be any GDPR implications, data sharing implications in sending work notices to 3 separate unions?
I don't know. I think you probably would have to take advice on that. I think that the employer will be able to justify, they'll have a statutory basis on which to kind of be issuing that information. The work notice itself won't contain union data. It will contain names, job titles, possible places of work, other sort of identifying features. The employer will have to, if there's multiple unions all taking action, the employer will have to have consultations with each of those unions. We saw in the government recently published its impact assessment for issuing for bringing in minimum service levels in schools and colleges, and in its own calculations worked out that given the number of different unions and schools, a national strike could involve 156,000 separate consultations. So the employer has to consult with each individual union on its action. I would expect that the work notices would presumably contain everybody's details sent to each of the unions of all union members and non-members who are named on the work notice.
Okay, so it's an interesting point there, because somebody else has asked, sharing lists of employees where they are members and non-members but that's for the employer to make sure that they comply with any GDPR. Yeah. That's where maybe unions can make sure that they're keeping to that part of the law as well.
Absolutely, and unions will have to be really careful about how they manage it. So there's going to be some challenges in unions in navigating the law, and I don't think we can give a sort of definitive answer on this. So, but unions will have to make sure that anything's kept securely. I mean, will they? The guidance suggests that unions might want to delete work notices after they're issued, but there might be a case for unions retaining them to monitor who's been the same people being named again and again. For example, are union activists being targeted? Are particular groups in the workplace being targeted? So unions will have to take advice. I don't think that we can give, but there are definite significant sort of data protection things to consider.
Thanks, Tim. So we've had an interesting question here that says, will it be easy for the government to roll out these restrictions to other sectors or other employers? Do we think this is likely?
Well, we know they want to roll it out. They've already consulted in fire and rescue and in hospital services, and the consultation for minimum service levels in schools ends on January the 30th. So we know they want to do this. I think what the government's approach so far has been quite sort of reactive. So if there's a prospect of industrial action in a particular service, then they suddenly announce plans for a minimum service levels for that service. Now they have to consult in the way they have been doing, and then the regulations have to be tabled in Parliament. There has to be debates in both houses of Parliament. So I think it took, but the government, if the government's got the appetite, it can rush them through. So I think it took, from memory, about 6 weeks from tabling the regulations regarding rail and so on. to them becoming law. So the government can act quickly if it likes. And I think you should notice, one of the sets of regulations the government's had sitting around for the last almost 12 months is regulations making it harder to fire and rehire. And funnily enough, the government hasn't found time for that, and yet it seems to be finding time to impose regulations bringing in minimum service levels. So a lot of this really is down to government appetite, and we know they may be unpopular, but they've still got a big majority in the House of Commons, and the House of Lords won't vote down regulations. So it's up to it's the government has those opportunities if it wishes to do further regulations.
Thanks, Tim. We talked a little bit earlier about consultation and that the employer has to consult with the union in order to before they can issue the work notice. Is there any scope for unions insisting on, quote, meaningful consultation as a way of delaying it? Or is that, you mentioned that the consultation isn't really detailed. Is it just sort of lip service kind of thing? Or can they dig their heels in on that one?
Yeah, I think that's one of the things that unions will want to press to ensure that the consultation is as meaningful as possible, and maybe suggesting that the employer hasn't met its duties. The guidance suggests that the employer should provide, for instance, sort of written material for unions to consider. So it's drawing their attention to what the guidance would be. So I think it is one potential way of pressuring employers and trying to string things out. But they'll employers and allowers were very aware they have to get a work notice issued 7 days beforehand. Even if they revise it then again 4 days beforehand. So they'll be very mindful. But yes, definitely one lever that unions will want to think about exploring to keep the pressure on employers.
That's great. So we have another question about the 4-day situation. I'm just trying to find it. One moment. It keeps moving on my list. Sorry. I think it was about who's sort of responsible for making sure that the 4-day rule is complied with. Is that the employer? Is it the union? Like, who kind of checks this?
If so, the employer has. This is an obligation on the employer. The employer has to comply with this, and as I said, the 4 days can include weekends and bank holidays and so on. It's then the union itself has a duty to send what the government terms compliance notices to those members named, and it has to do that obviously before the strike action starts. So yeah, I mean, if that. The union will be able to sort of point out that any amendments to work notice issued after, within 4 days of the strike action are not valid.
Thanks, Tim. You mentioned that there's a number of ways perhaps that unions are going to attempt to frustrate this. A minute ago. What are some of the other things that unions could perhaps do? There's the meaningful consultation and the insistence on that. What are maybe some other actions that we know that could be tried?
We're still sort of, we are still sort of feeling our way with this. I think employers will want to be reminded of their health and safety duties, for example. The need for that they aren't waived just because it's a work notice. I mean, you can easily see how, for example, even with a 40% of timetable services, how a commuter rail line could become very unsafe if 100% of people try to get themselves onto 40% of trains. And so, it's reminding employers of their duties under those, and workers themselves being aware of what their rights are when it comes to sort of ensuring the safety of those they sort of deal with as well. So we will want to look at things like that. I think some of this is long run, that being aware of how many people are normally working in this area of your organisation, and have the numbers who've been brought in look implausibly high, considering what the minimum service should look like. So building up the evidence to ourselves to challenge, and sort of building up the evidence of actually does the way these laws have been implemented, does it mean that a large group of people are now not able at all to take strike action? So in border security, I imagine maybe thinking about, particularly in smaller ports, does that mean that if you work in a smaller port, you're never able to take strike action because it's meant to be a service like any other day? So there's no sort of, as it stands, unions will know their own services better than we would. But I think it's going to be a case of, for some of these areas, just building up evidence over time, so the employer goes back again and again, that we can begin to challenge some of the actions they're taking.
Thanks, Tim. So I know that the legislation is called the Strikes Act here, but we've been talking a lot about minimum service levels. Even with the issuing of a work notice, if the minimum service level is not met, so for example, if union members did a go slow or it still wasn't met, would the union still be penalised in that situation?
I think these are things that unions will have to think about carefully. I mean, they are.
Oh, I think we might have frozen Tim for a second. Is that the case?
They can issue one letter telling you to turn up to work, and then another one the next day telling you not to. So unions will have to tread carefully. But I'm sure when there are, particular wrinkles in particular services, that unions will know from previous action, particularly actions short of a strike, what other action might be taken alongside strike action that will mean that actually might help render minimum service levels ineffective or less effective.
Tim, I'm really sorry. I'm going to get you just to say that again. You froze for about 6 seconds. I'm really sorry, and you probably couldn't hear me. So just summarise again the answer to that question, if that's okay. Not all the detail.
I think it's not a straightforward answer in terms of what else unions might do. They are under a duty not to undermine their own, the compliance notices they send to unions, to union members who are named on work notice, saying that they're named and that they should be going to work. There's an obligation under the law not to then subsequently undermine that, for instance, by sending another letter that says the opposite. So unions have to be quite careful not to fall foul of the legislation. However, I imagine a lot of sectors, unions are quite experienced in various, action short of a strike that can be as effective as strike action sometimes, or will help to render minimum service, work notices ineffective or less effective. So there's not really a straightforward answer, and I think unions are going to have to be really careful and take advice. And I think we're still feeling our way a bit about to what extent employers will be. I mean, I think we can expect employers to monitor quite carefully what communications unions are sending, and seek to have strike action deemed unlawful on that basis. And we can expect employers to, as they do at the moment, often turn to injunctions where they believe that a union has broken its statutory duties, or, and this is more untested, seek damages from unions where they claim they haven't. So the consequences of falling on the wrong side of this legislation are really severe, not only for individuals, but I think in particular for trade unions if they get this wrong. So tread carefully, I think, is the overall picture.
Yeah, that's great advice, Tim. And I think on something like this, always check with your union, your full-time officer or regional official, just to clarify around there what their strategy is. Okay, we've talked about the different sectors that this is going to apply in. So a couple of people have asked, will this apply to only certain employees within that sector? The example they've given is within a hospital. Is it just particular people, nurses, doctors, etc., or could it be the porters, cleaners as well?
I think in hospital, we haven't seen legislation on hospitals, but I think the expectation would be that it would be anyone sort of needed to ensure the functioning of the hospital. Now, the question will then be, is there more than one employer who can decide whether to issue a work notice? So a hospital trust might issue a work notice to directly employed staff, and we'd expect them to probably issue them to staff of lots of different sort of levels and functions. But then sometimes work is outsourced. So will somebody who works for a contractor, will that almost it should be that contractor who has to issue them the work notice? Will they do that? We don't know. But there's not, in the regulations we've seen so far, there's little sign of being restricted to only certain occupations within those services. It's kind of anyone who is necessary to keep the service going.
Thanks, Tim. We've had quite a few questions about the equalities aspect of this. Now, firstly, does the law or the regulations reference this at any point? Like, are there any equalities implications for the issuing of work notices, for example, or is it silent on that?
I think employers are still going to have to. They're still subject to equality legislation. And so unions will want to check: are there people who are are there groups who are being particularly disadvantaged? Those particular characteristics being particularly disadvantaged by the way that work notices are being structured. So so that's something to be aware of. But there's nothing that says because you're issuing a work notice, you're not subject to the same sort of legal obligations that you would be otherwise.
Yeah, thanks, Tim. Some comment that's been made that I think it's quite important for us to, well, lots of comments actually, is saying that minimum service levels are exactly that. It's not staffing levels, it's the service. So, for example, to run 40% of timetable trains might mean 80% of passenger trips. I'm reading exactly the comment here. So it might require more than 40% of staff. I mean, this isn't a question. This is just something that people need to be aware of. It's not necessarily 40% of the people. It's the 40% of the service.
Absolutely. And you can also see, when it comes to roles like signalling, you can't just have, you can't just sort of have 40% of a sort of signal service. You're either maintaining the line, keeping the line open, or you're not. And so there's really serious questions to be asked about the extent to which this impinges on the right to strike of occupations like that, where you either run it or you don't. So yeah, we would expect, certainly with the trains, more than 40% of staff having to do that, and I imagine we'll see similar examples in other services if the government rolls out further minimum service regulations.
Yeah, you used the example of a signaller there, Tim, which someone way earlier in the hour said, you get many like lone signallers. You can't have 40% of one person, so it's a bit nonsensical. I think there are some other issues in this legislation that are a bit maybe not contradictory, confusing, a little bit absurd. I think we just all need to be aware to look out for that, to make sure that you always check, seek advice from your union. Not everything is set yet either. I think there's 3 sectors that we're still waiting for the regulations on. So there's still a lot of there's a lot still to be to find out about this. It's not something that's kind of we know everything about now. On that note, over the next month or 2, maybe 6 weeks, we at the TUC are also going to be issuing or publishing a short e-learning module about this. It will be, watch this space, sign up to our mailing list. We will be making it available to everyone. We're writing it at the moment. We're working with Tim to do that. So we will, hopefully in the next few weeks, find out a little bit more and make sure that is included in the module as well. Okay, I think we've got time probably just for one more question. So I'm just going to see what else has been added here. Our most popular question that's been posted is about illness. So say someone has been issued a work notice and they're ill. Do they then, I think someone might be discussing what do they do? What would their action be other than the usual calling in sick? Will someone else then be issued with a work notice in order to cover that, for example?
No, that's a good question. And if somebody is sick, they would follow their normal workplace procedures. There won't be another work notice issues to bring in replacement staff. But what the legislation does do is allow the employer to have some leeway within the number of people that they put on a work notice to cover anticipated sickness absence. So that might be based on past experience, or it might be based on sort of past experience in terms of industrial action and when they've previously issued work notices. So that's another thing to keep an eye on, is the employer naming far too many people because they've got some spurious claim about how many people are likely to call in sick. But no, it's up to the employer to have that built into the work notice. You won't suddenly be issued a work notice on the day because your colleague has called in sick and now you're expected to cross the picket line yourself.
Thanks for that, Tim. And so one final thing, who will sort of police this? If the employer is not following the law, what happens then?
So this will be another job for the lawyers. I suspect. I think this will be people turning to the courts to have sort of effectively work notices quashed. But again, we're sort of feeling our way a bit. There's nothing built into the legislation that says this is how you go about challenging it. But we'd expect unions to probably turn to the courts. But I imagine it'll keep the lawyers busy for some time.
That's really helpful. Thank you. And of course, like we said earlier, I know some people didn't join from the beginning. We've already got examples of some employers saying that they're just not going to do this. They don't have to comply with this. It's up to the employer to issue the work notice. So okay, I'm going to wrap up now because we've answered a lot, I think, in the last 50 minutes. Thank you, Tim, so much. I know I threw some random questions at you at some points, but I think we've covered a huge amount of information. Just to recap, we will be publishing a module, an online learning module in the next few weeks that will go into some of this in a little bit more depth and explain any of the new information we find out that's coming up. We are campaigning against this legislation. Please take a look at the page on the TUC website, which we'll make sure is sent to you, and we'll put in the chat now. There's lots of information about how you can get involved in Cheltenham, or if you can't come to Cheltenham at the end of this month, there are other things you can do to express your opposition to this law. I think it's really important that we do keep up that opposition and that we stay stronger together. And yeah, already seeing from people that they're going to join us in Cheltenham, which is really great. So thank you everyone for joining us today. Like I said, this is the first of our webinars of 2024. We've got a really exciting program lined up from here through to May. Loads of good subjects, including things like cold temperatures, which I think is very suitable for today, in workplace restructures, mental health, pay bargaining. There's something for everyone. Do take a look. I'll see you again soon. Thanks for joining today, and